The Court of Justice has also heard a number of decisions on reference from member states. In order to ensure harmonisation of European law, courts in member states can refer questions to the Court of Justice, and a number of member state courts have done so. We have a number of decisions already. Interestingly, a decision about the Arco lamp called Floss, referred from Italy, dealt with the question of whether or not copyright and design rights should subsist at the same time, and whether the design regulation reintroduces copyright for products that had passed from copyright protection in Italy. I'm not sure that case is rightly decided, and I think we still have more to hear about it. Another decision from the Court of Justice is Fia and Cul-de-sac, a case about cuckoo clocks referred from Spain. That case was about whether or not a design is owned by the designer, or in this case, because it was a commissioned work, by the commissioner of that design. The regulation clearly sets out that designs designed by employees are owned by the employer, but the Court of Justice held that a commission situation was different, and that in that case it was the designer who owned the design, not the commissioner of the cuckoo clock. Another decision from the Court of Justice is called Celea, which involved bollards, traffic bollards. It's interesting for two reasons. First, the Court of Justice had to decide whether or not a registered community design was a right to use or a right to prevent third parties from using, and it decided the latter. That much is clear. Perhaps more interestingly was the court's answer to the second question that it was asked, which is the intention of the filer of a registered community design relevant? The court held not, and I think that decision will have far-reaching effects on how we interpret registered community design rights, because we need to look at it objectively, not taking into account the intention of the entity filing for the registered community design.